Welcome, everybody. My name is Jeff Fowler. I'm the president of the Apartment Owners Association of California. It's great to have you with us today. We're going to cover some of the top questions that AOA members are asking in the Bay Area with one of a 30-year veteran in real estate and landlord-tenant law, one of our attorneys, and he's a guy that also writes the legal Q&A for the AOA magazine, so you're in store for something great. And also you'll be able to ask some questions as well, so just save those until we're done because we may ask your question, and then when we finish up you'll be able to ask some. And anyway, AOA is the largest individually organized group of apartment owners here in the state. And really our goal is for you to be successful, and we believe we can achieve that by providing you information that will things that will keep you in the know, help you avoid the pitfalls, and find things that will make it easier and more enjoyable as you're managing your property. And you know, it's so funny, we just had a live stream at 10 a.m. Today we had another live stream about the top tax tips with a different speaker, and afterwards one of the members called me and said, you know, when you talk about member benefits, you should mention tenant screening, because man, that's been the best thing for me. Here I am, a 20-year member, and all my tenants are great. And so I was like, yeah, you're right. And so yeah, tenant screening is definitely something unique. That's something we do in-house and we've been doing for a long time. And we have a double whammy eviction report, and that's literally two different reports. And so I thought I'd just mention that. A lot of the times, if you can get the right tenant on the front end, then hopefully, you know, on the back end, it's not an eviction. On the back end, it's just them moving on to better and bigger things, right? And so, yeah, I'll give a plug for that. And if you're not a member, definitely I want to extend an invitation for you to join. And there's a full money-back guarantee for the first year that you're a member. And so we really believe that we can help you do better, and we back that up with a guarantee. And also, you know, you may have missed other videos that we have. We have a YouTube channel called AOA USA. So if you go there, you'll see that there's a lot of different content that we have. But we had a local, Bay Area local exterminator speak not too long ago about how to protect your rentals from bed bugs and all the other undesirables. And so that was so good because she exclusively deals with rental property owners, and my goodness, it was not just talking about bugs, but really talking about every phase. And you'll want to check that one out if you missed it. And then also on March 2nd, we have a live stream coming up that I believe you'll be interested in. And we have an expert in California building code, and he's very familiar with the code violations that frequently occur for rental property owners. And so he'll be doing the third part in a three-part series. Two of those parts were covered in person. We did record those, and they will be available for AOA members, but we're still working on producing those and getting it all put together. We will also have that another seminar that we did that we recorded with an attorney just talking about habitability. And so we're going to put all that together and hopefully get that to you guys sooner than later. And anyway, so those are just a few things that are coming up. And right, so we're going to, again, Q&A at the end. And if you need a closed caption, please watch us on Facebook. And there you'll get live captions where if you're watching on YouTube, they just don't have that live. And anyway, so we're going to go ahead and get started. Rich, hopefully let's get a screen here with all of us together. And all right, here we go. There we are. We're side by side.
Welcome back.
Yeah, even though we're not side by side. Well, thank you so much for joining us, Rich. We're just really anxious to hear from you, things that might have been going on. Can you give us an update on the status of the eviction moratoriums in the area?
First of all, it's good to see you and nice to be here. It always inspires me to do a little research and sort of update my own understanding of developments. But so as to developments in the litigation in basically Alameda County, there have been some developments, and I'm really happy to share them with the members. So first of all, just to sort of quickly recap, there's two separate efforts. One is the city of Alameda, which is a city in the county of Alameda, filed an action in unlawful detainer against one of its tenants. The city of Alameda owns rental property, and one of its tenants failed to pay the rent. So the city brought a unlawful detainer, or attempted to bring an unlawful detainer against that tenant. And not surprisingly, the Alameda County Superior Court, which is acting as a gatekeeper for all unlawful detainers filed in Alameda County, and which needs to have the plaintiff explain why the pending unlawful detainer is exempt from the Alameda County moratorium, which basically prohibits any residential unlawful detainer that isn't based on the state Ellis Act or a public health and safety threat by the tenant. So the Alameda City Attorney explained to the Alameda Superior Court that the county's moratorium should not apply within the city's jurisdiction. And it submitted a lengthy explanation why the Superior Court judge, a Judge Kolakowski, declined to consider that explanation and simply denied the request for a summons for the unlawful detainer case to go forward. So the city, through private counsel at Farella, Braun, and Martel, pretty well-known San Francisco firm, filed a writ with the First District Court of Appeal. And this basically is a request to a higher court saying that some lower body, in this case the Superior Court, is not doing its job, and therefore it needs an order from the appellate level to order that lower entity to do its job, in this case issue a summons. So there was a lot of briefing back and forth, and I was keeping track of the docket. The First Circuit publishes, has a website and publishes the ongoing developments in any given case. And so I saw, and I think I reported in the last AOA magazine, the Q&A, that the appellate court had effectively agreed with the city of Alameda's argument that the Superior Court needed to at least consider the city of Alameda's request to issue a summons based on the argument that the county's law should not extend to the city. And so after a bunch of back and forth, there was a filing from Monday by the private attorney, a guy named Thomas Mayhew at Farella, Braun, and Martel, which I couldn't open. And so I called him this morning, and he actually answered his phone. I thought, well, he's a busy guy. So we had a nice chat, and he really brought me up to speed. Sent me a copy of the Superior Court's order, which basically said, and we're not going to contest this application. The Superior Court has no skin in that game. They're just trying to execute the orders that they receive from the county or any other body that has jurisdiction over an issue. They invited, and the appellate district invited, the county of Alameda to submit an application or an opposition to the Alameda City application. And according to Mr. Mayhew, who was quite generous with his time and taking me through these developments, so I really want to give him a shout out. The county, basically, the county attorney let him know that the Board of Supervisors elected not to participate in that particular effort. Now, there's a couple of explanations that may apply. One is they see the handwriting on the wall that the various states of emergency are about to be lifted. California, Governor Newsom has ordered that the California state of emergency be lifted as of February 28th. And so they may have seen that as underpinning their local justification for continuing the local state of emergency. And I'm not exactly sure, if that is the case, but that's one idea. The other is they didn't want to get a bad ruling. which could hamper them in future efforts to try to impose the county will on city jurisdictions. And so, for whatever reason, they elected to just punt. So the Superior Court issued the summons to the city of Alameda, allowing them to proceed. Now, that's not the end of the story, though, because even though the county chose not to try to justify its moratorium, that doesn't prevent the tenant. And they are now being represented by, the local tenant defense attorneys who are, as Mr. Mayhew said, he was looking forward to a good fight, a worthy adversary, because the attorneys that join some of these tenant advisory services, legal services, come with some pretty hefty resumes. They're Ivy League graduates from law school who join these organizations out of a sense of, social justice. It's also a good place to get training that isn't a big firm environment. So they get, they go to court a lot as opposed to maybe joining a big firm right out of Harvard Law School. But they're competent people. So I think Mr. Mayhew was looking forward to that tussle among equals, in effect, because, like I say, Farrell Braun's a pretty good firm, pretty well resourced, let's say. But at any rate, that story is still unfolding, because when the summons is served on the tenant, you can anticipate, I do, that the tenant's attorneys will file a demurrer to argue that the county moratorium prevents the eviction from going forward, even though the Superior Court issued the summons. And so then Judge Kolakowski will be squarely faced with that issue, and that will be a fascinating ruling. Now, however it goes, it wouldn't surprise me that either the losing party will try to get another writ to the appellate court, because again, the appellate court didn't rule on the merits. They just said that the Superior Court had to consider the city's application for the summons. So it'll be really a first impression hearing for Judge Kolakowski when that tenant's demur. Presumably they will. I mean, I just would be shocked if they don't. Go through that proceeding. So again, stay tuned. Although, if the judge does what I suspect, which is to allow the demur to overrule the demur, although I don't have any reading there, it will basically allow all of the local cities, the people that have properties in cities, incorporated cities like Fremont or Hayward or City of Alameda, to go ahead and start submitting their own unlawful detainers that are based on things other than public health and safety or the Ellis Act, because that, assuming the city itself doesn't have a moratorium like Oakland, has its own moratorium. But at the moment, I don't believe. Now, it's possible that Fremont or Hayward may enact their own local moratoriums because they've been covered by the county, and so they haven't had to bother with it. So it's just kind of stay tuned. I hate to not ever be able to give anything definitive, but that's the best we can offer at the moment. Now, that's the city Alameda action against the county moratorium. There's a second subset of litigation, and that's where various property owners, supported by a couple of property management organizations, have filed suit against the city of Oakland and Alameda County, trying to have both the city and county moratoriums declared unconstitutional, basically, invalid and inapplicable. And as I reported previously, though, that effort was set for a summary judgment hearing in September, late September. A summary judgment hearing is where one party asks the court to just issue a judgment without a trial because there are no facts that need a jury to determine. And after about 2 months of sitting on it, the district court, this is in federal district court, Northern District of California, issued a ruling denying the summary judgment motion, arguing that it did involve facts that needed to be determined by a jury. So I just checked the docket this morning, and there's a little bit of development. The plaintiffs submitted an application, a motion to be heard this morning, basically to have the district court's ruling submitted to the appellate court on a sort of an emergency review basis, another writ proceeding. That's being opposed by the county, and I didn't see anything from the city of Oakland, but I assume so. So there's actually a hearing this morning at 9:30, and so I assume there will be a ruling issued eventually. But have a feeling that is just going to be all moot, that both the city and the county moratoriums are going to be lifted before there's any ruling from the courts, the trial court, and then any ruling by the trial court can get appealed to the appellate, the Ninth Circuit, and just endless. So it's going to come down to what it's always going to come down to, which is the county and the city recognizing the moratoriums are just no longer appropriate and haven't been appropriate for quite a while, but finally stepping up and acknowledging that. Now, the other thing that I saw, a client actually sent me notice this, and AOA has probably sent out a similar notice, but I'm just going to go to read a little. Let me just see what I have here. I have a bunch of documents up on my screen that I might share, but hold on one second. Let me just get to the one I want to get to. Anyway, there is a phone-in. There it is, Alameda County. And I don't know if I can share my screen, Jeff, but if I can, let me see if I can.
Give it a shot. Let's see what happens.
So, all right. So this is, you're seeing this, Alameda County.
Yeah, there it is. Yep.
All right. So let me try to get you guys out of the way. Alameda County housing providers invited to town hall. Now, this is, so there's a new supervisor, and she may be tilting the balance.
Oh, wow.
So this guy, David Halbert, has been the one advocate for trying to revisit the Alameda County moratorium. And so the Board of Supervisors keep overruling him in terms of having a hearing and allowing, the people to present. So this has been rescheduled now 3 times. It's now scheduled for tonight from 7 to 8. You can appear. You can, if you go, there's a Zoom link, and I can, again, if AOA doesn't have this on its website, I can forward this to Jeff, and it can be posted. So if anybody wants to appear, this would be a chance. So I'll just share that. And, I don't think there's any question, but that the Alameda County supervisors have had their ear bent by property owners, but they haven't allowed it to be done in public. So this might be the first time for that. And when they get 300 people, all saying, "Why do you still have a moratorium?" Anyway, it should be interesting. I would certainly zoom in if I don't have some other pressing engagement. But for you property owners.
What we'll do is we'll put the Zoom link at the bottom of the video for people to get that. So people, at least that see it today, they'll be able to get to that.
Yes.
And definitely show up. And that's important to show up. And he's done it one other time. And I think Millie also is voted with him, right? So there's 2.
Right. So it has been 3-2, but apparently there's a new supervisor, because the reason I say that is, let me go to this other screen that may be of interest. I may have, hold on one second. Anyway, I was just reading an article on the current, because we're going to talk about this in a moment in terms of the do I have to do anything new for
consider anything.
Yeah. And there is some confusion there. So let me, I must have closed that page. So I'll just explain what I'm talking about, and let me just stop sharing here.
So did you want to go on to the next question?
Sure. And the next question.
Okay, so that was the one with, are there any new considerations that I need to be aware of as I select a tenant?
Well, yeah, the biggest one, which is something that, again, I think I wrote about in the maybe January Q&A, Alameda County passed what's called a fair chance ordinance. Now, Berkeley and Oakland have already had these, and it basically prohibits the landlord from asking any questions about the criminal background of the applicant. But there's been some confusion as to when that ordinance takes effect. And I think, as I mentioned in the Q&A, all I could find was articles from news reports like Channel 7. And they said it would take effect at the expiration of the Oakland moratorium, April 30th. And I've written to these people and the Chronicle reporter. I've reached out to ABC. I'm just like, where is this information coming from? Because I've scoured the Alameda County website, the Board of Supervisors website, and I can't find anything that makes that reference. In fact, I emailed, one thing, her name is Supervisor Chan, and this is pretty funny because I used the email address that I got from her website, District 3, I believe, and it bounced back and said, "I'm sorry, that cannot be delivered." So they're like in hiding. I really don't understand it. So I still can't tell you what is going on with the local moratorium on, the local ordinance prohibiting asking tenants about their criminal background. My recommendation is not to do so, even though I know that's kind of, I'm just looking at my email, BOS District 3 at acgov.org, which is the address on our website, asking her to give me some, update. So this is Supervisor Tam. As you said, I'm presenting a seminar shortly on updates in the county ordinance, and need to speak about the fair chance ordinance because I'm having difficulty finding the status of that ordinance and whether it's in effect. Because there was another report that this Supervisor Tam may be the deciding vote because the ordinance itself apparently needed a second reading to take effect. And so there was concern in one of the news articles that she may prevent it from taking effect by, voting with the two who previously were not for it. So there's just a mystery going on with that right now. I wish and I apologize. I mean, I think I should be able to figure this out, but they're an opaque organization.
Yeah, but that's good though, because you have to have an ordinance signed and it's not there today. So that's just a good status update, I think.
Well, I'd like to be a little more, concrete about, it passed and it takes effect January 30th, or it didn't pass, and it's more than annoying that the Alameda County Supervisor website doesn't have more update on this, or the Alameda County or the Oakland Rent Board, I wouldn't necessarily expect, but yeah, a little frustrating. So just, I have an associate I direct to research these things, and she does a pretty good job. But between us, just could not get that answer. So,
right.
Stay tuned.
And that's, but I mean, in not getting an answer, that is an answer for now. So thank you. Thanks for all the effort. And maybe someone like Halbert would be, I know he's really responsive when I write. And so maybe a more responsible supervisor would be better. Right?
To get my email bounced back by using the exact email that was provided on Supervisor Tam's website, I don't know what else to do. I mean, but yeah, if Supervisor Halbert is a little more responsive, then somebody can email him, just ask him what's going on with that fair chance. Because it was the package of legislation they preliminarily passed. It was a eviction control ordinance, the fair chance ordinance, and then the regulation or the registration ordinance. So we really need to know what is going on with those things. Right. I mean, if I'm a member, I want to know.
Right. And, those things have to be finalized and signed. So
anyway, all right, I'm going to keep looking for it. But if you have an inside attracted Supervisor Halbert, please use it and ask him to explain what's going on with that. And then also I have to look and see what email addresses we have for District 3 because maybe we have something updated. I don't know. I'll have to look at it. I would have to trust her website, but apparently not. So
yeah. And then beyond that, was there any other considerations that were more statewide?
No, nothing since the last time we spoke in terms of any new, potholes or sand traps that you got to look out for. That's pretty much the only news.
Okay, so maybe it's an older one that people wouldn't be aware of, but where at the state level, I can't remember the name of what the number was on it, but it was saying that you can't deny an applicant based on COVID rent debt. That one I can't remember.
I think that's been in place for a little while.
Right. So it's been in place. I just don't. My concern are, do people know about this or not? And so I just wanted to bring that one up.
It's so easy to forget. I mean, I'll be honest. I have learned and forgotten, so much.
Right. All of us.
Legislation and litigation and developments, that I have to go back and read my own articles, to remind myself, all right, that's right, So it's easy not to, to retain that awareness. And I guess, it's really incumbent on the professionals to keep their forms updated and for people to use current forms. I wouldn't use anything more than a few months old, basically. I mean, I would check with whoever I got my forms from for an update. I mean, because those things should reflect the current status and really prevent people from just blundering into, some violation by having asked or required something they're not allowed to.
Okay, here's a question that we're getting. Is there a timeline for tenants to pay back rent that is owed?
Yeah, there is. And I'm only chuckling because I just went back through this and I had my assistant go back and look at all these Bay cities in Alameda County, because really they're pretty much the only place that still has these kinds of restrictions. And they're sort of all over the place, but the bottom line is wherever your property is, you're going to have to specifically look into it. But at latest, Alameda County, which again may apply to the cities, may not, that's part of that issue, has a moratorium on demanding unpaid rent until 12 months after the expiration or 60 days after the expiration of the state of emergency. And then the tenant has 12 months to pay the rent before it can be subject to collection. But state law, AB 2179, the last version of those series of state laws that came out, basically put a deadline. It was going to be March 30th, but now it's August 31st, which is the absolute deadline for a tenant to be able to pay the back rent without being subject to a collection action. So wherever you are, August 31st will be, absent a new state ordinance, which I do not anticipate, will be the absolute deadline for a tenant to pay back rent that accrued during the COVID pandemic period. And they have dates that are described, but basically anything before March 31st of 2022. Let me restate that. As long as the moratoriums in Alameda County are in effect, any rent that is due cannot be subject to an unlawful detainer while that moratorium applies. But at the end of August, regardless of what any county moratorium or city moratorium says, that rent is due and can be subject to a collection action. It will not be the basis to bring an unlawful detainer for non-payment of rent, but will be subject to collections. Now, that's the current state. So individual cities have different rules, but any like Hayward, I think Fremont, I have a list of them. And if anybody has a specific question, I can try to just refer you to this summary that my assistant put together. But most of the local Alameda County cities just defer to the county, and which says basically the rent is not due. And then that tenant has 12 months to pay it once it does become due. Part of me just says, I would file a small claims action. And let the small claims court figure it out, because it is confusing. But August 31st appears to be the absolute deadline for tenants to pay back rent or be subjected to a collection lawsuit.
So with that, you were suggesting to file the small claims. With the small claims, are you saying to do that now and get the judgment now, or so that you can collect after, or do you mean once it happens, then after?
It's first of all, if you're an incorporated part of the county, and you might be able to rely on these recent developments that we've just discussed, you may be freed from the county's moratorium on when the rent can be collected. Again, it's beyond confusing. Part of me is just sort of, thinking out loud, because as an attorney, I can't really advocate a course of action that, may be precluded by existing legislation. And it is relatively clear that the city and the counties are trying to prevent these collection actions as far as they can, as long as they can. But also, that's a defense, arguably by the tenant. But there may be consequences in the ordinances themselves because certainly if you try to evict a tenant under the ordinances when you're not allowed to, there are consequences.
Right, yeah.
And so without having gone back and looked at, I'm going to assume that bringing a small claims action, even though that is completely a litigation privilege action, we could have this conversation for a while, but there's a thing called the litigation privilege, which shields people from any claim that they violated the law related to whatever they filed in court. The only exception is something called malicious prosecution, which is to say you brought a case that had zero merit. And whether you can argue that these, like I say, the county moratorium shouldn't apply to the city as the city of Alameda's attorneys did successfully, more or less, it may not be worth the headache. I mean, I know it's a ridiculous, merry-go-round of uncertainty and frustration, but obviously the safe thing is to wait until August 31st.
Yeah, I'm just thinking if you wait that long and then they're long gone, then you won't even be able to serve them.
It's a to use an expression, and there's just not a lot of good news on that particular issue. Again, somebody could go forward, bring a small claims, let the tenant defend it on the basis that it's precluded by the ordinance, or maybe they just default and you get a default judgment. If the tenant's still in possession, obviously they're probably not going to default. But I have had clients tell me that when they started that action, the tenant came around and started talking seriously about, getting right, because you can still enter into repayment agreements.
Right.
So in one case, the tenant and their pro bono attorney, offered to pay 90% or something if my client withdrew the small claims action. So it bugs me that I can't.
So you do see people filing small claims actions for what's owed, not unlawful detainers, but just the small claims.
I had a client in Berkeley, brought that against the tenant in Berkeley, and the defense attorney, one of the free defense attorneys, didn't argue that it was precluded, just reached out and said, look, will your client take this amount of money to dismiss the small claims? So whether they just see the handwriting on the wall and the tenant had the money and wanted to be done with it, because, my client did waive, some of the money. I mean, money in hand obviously is a good thing. But got the bulk, certainly got the tenant to pay a lump sum payment of the bulk of it. So, and maybe that's the exception, because, who's got 10,000, laying around, or 20 or whatever, some of these numbers are pretty high, I'm going to guess. Hopefully most property owners have gotten, the rental assistance program money, but, okay. Again, whether I'll just leave that to your conscience. I mean, again, I can't say one way or another whether it's a good idea or not.
Okay. Yeah. I'm just thinking, if somebody's around, it's a whole lot easier to get it. And we all know for certain that if you don't have a judgment, you can't really, you're not going to successfully collect anything without a judgment.
No.
So you got to at least get a judgment, even if it's a small claims court judgment. So it's just timing on that. You're hesitant to commit, but at least those facts are laid out there, right?
Well, a small claims judgment, if you get one, is it's just as enforceable as a superior court judgment. Yep. So you have all the tools available. So it is not a junior judgment. Let's just say a little brother judgment. It's entitled to the full force and effect of California enforcement of judgment law.
Right. And I just know when it comes to approaching a collections agency, they really need that to be able to collect. Whether they're even going to be able to connect. Yeah, whether they'll be able to collect or not, it's another thing.
But my guess is they're not going to. I mean, my understanding, there are two different types of one that will take and write your demand letter saying, if we're going to report you to the credit reporting agencies, and that gets people's attention, particularly people who believe they have a good credit rating and want to protect it. Then there are other collection agencies that require that you have a judgment in hand, and they'll go and enforce it and take 50% of whatever they collect, or whatever their percentage is. But that's what I seem to see.
Right. Anyway, so it's just good I know that a lot of our members are seasoned and they know all of these things. It's just there's maybe a handful that aren't aware of those things, and it's just good to talk about it, I think. All right, so here's
if anybody has specific, so it depends, on your jurisdiction and whether or not you should go forward. So that's something you may want to consult with somebody, me or somebody, and get that kind of guidance. And then you can say, well, this is what I was told by the attorney. And that's usually a pretty good shield against claims of malicious prosecution.
Right. And with our collections, I know that they want the tenant to be out before they start doing the collection. But that doesn't mean you can't get a judgment beforehand. So those are things I'm not 100% sure on myself, but just
I don't think the tenant's possession precludes proceeding against them. It's just whether or not a moratorium applies. So
yeah. And that's just the people we're using today. And anyway, we're going to have a big update on that pretty soon in the next couple months here. So I'm excited, but that's something for later. Question number 4 here. Can I serve a 3-day pay rent or quit to tenants that are not currently paying? And I'll say, let me rephrase this question to where can I do that? Because I know there's a lot of places you can't. Where can you serve a 3-day pay or quit?
Yeah, I can't speak for Southern California because I keep getting, little heads up that Los Angeles City Council has reenacted a moratorium after it was allowed to lapse. So I really can't speak to Southern California, but in Northern California, basically a old style 3-day notice for rent due after July 1st certainly is available any place that doesn't have the moratorium, which is to say Alameda County until, although again, as we talked about, the incorporated cities, you can probably proceed now, but the cities themselves that have moratoriums like Berkeley and Oakland, you can't. So basically, I would say anywhere in incorporated Alameda County other than Oakland and Berkeley, you can proceed. And then in every other county, but again, you almost have to go and do a quick check because Solano County, Contra Costa County, I have to check, just to make sure they haven't done anything, whenever I get an inquiry. But yeah, if you are able to go forward, your 3-day notice, your old school 3-day notice is appropriate. And then good luck, because some of the courts just are taking a long time to process these things. All
right, so we come to our final question here, and then we can, if there's time, we can take some. Hopefully, we get some questions too. This is taking longer than we ended up going longer than I thought here. What are the requirements for tenants requesting to have an emotional support animal?
I would refer people back to I think it's about a year now Q&A and I'm going to just bring up. Let me do a quick review of my document here.
Yeah, you put it in your legal Q&A. And guys, while he's pulling that up, he's referring to his monthly column that he does in the AOA magazine. And so he does that for the Bay Area, for Northern California. And it was really you addressed it very thoroughly. And so we could refer people back to that one. And this is state law. So no matter where you're at, it applies. And so able to find that or?
Hold on a second. Yes. So I have it's not that one. Hold on one second. It's not that one. So the statute SB 774. So let me just share a screen here real fast. And pardon me while I look away because that's what I'm looking for. So we're looking at my notes for another inquiry. So basically, starting January 1st of last year for a California tenant who wanted an emotional support animal. The landlord was entitled to require that they provide. So there's two levels. The request for reasonable accommodation is a both state and federal concept that a tenant who's disabled is entitled to ask a landlord for what is called reasonable accommodation to the landlord's standard practices, if that accommodation will allow the tenant to enjoy the normal lifestyle of a non-disabled person. And most commonly, and for the purposes of this conversation, that involves the classic emotional support animal, which is different from a service animal. As we repeatedly say, a service animal is a trained dog that is specific to a task, whether it be a seeing eye dog or a dog that helps deaf people. So and they have no restrictions. They can go anywhere, and you cannot say anything about it, and so on. Emotional support animals are sort of on a sliding scale. The previous to the legislation that took effect last year, tenants were just going online and getting a certificate from anybody that happened to have a website by saying, yes, I feel depressed, and they would get a certificate saying they were disabled and they needed an emotional support animal. So the legislature, decided they needed to tighten that up. And so they passed the statute that amended a variety of health and safety codes, this one in particular that I'm looking at. And it basically said, that the tenant has to provide documentation from a licensed healthcare provider that has been in a relationship with the patient for at least 30 days, and is licensed in the jurisdiction, and completes a clinical evaluation of the individual. So one of the things that I had trouble with was whether this clinical evaluation required an in-person meeting or at least a remote meeting. And I think the answer is fairly clear that it does require a personal evaluation of the patient, but that can be remote. So there's so this is the definition of the emotional support animal. And the one thing that's also clear: you cannot charge any additional rent or anything like that, security deposit, any of that, if the tenant is entitled to the emotional support animal. And so basically now the tenant has to provide this documentation. And still doesn't mean the landlord is obligated to grant the emotional support animal request, but I don't know of a circumstance in which I would tell a client who receives this documentation to reject that request. Because this is kind of what this was meant to do, was bring some a little more certainty to the process. Now, if the animal is violent, there's still an obligation that the tenant has to make sure that the animal behaves itself, doesn't create a nuisance, either through its, activities, peeing on the floor or, crapping on the sidewalk and the owner forgets to pick it up, or is, threatening to people, growling animal, lunging animal. But there's no restriction on size, breed. I was a little surprised at that because I thought there was a prohibition on certain animals, because there was some sort of a report that insurance companies would reject coverage if it were, for example, a pit bull or a Presa Canario or some of these other, reportedly aggressive animals. But the California Code of Regulations makes it clear that you cannot decline the request based on that. If the animal demonstrates those kinds of tendencies, then you can take action as appropriate, but you can't prejudge the animal.
Great. Well, great. I hope that's helpful for everybody. So you have rights as a rental property owner. You have some rights here. You don't have to take the thing that's online from Oklahoma. You can. They have to have these things. You can ask them to provide this information, and it's perfectly legitimate.
And you can go online. I think the California Consumer Affairs Department will have a list of licensed healthcare practitioners, because my client actually provided that information, which is great because clients teach me just sometimes as much as I teach them. So collectively, we hopefully will get to a certain answer in some of these things. But yeah, you can definitely confirm that the healthcare provider is a licensed practitioner in California. Confirm that they have had a relationship for at least 30 days. That they've done the clinical evaluation. So there's a little more, credibility to those documents.
Great. Well, all right, we're going to go right to questions. Thank you so much for taking the time today for this.
Sure.
Can you handle a few questions?
I can. I'm just noticing. I hope nobody go back and reviews the previous ones. I think I'm wearing the same tie.
Well, you just gave that one away, huh?
It's really it's a prop from here on down.
Oh, okay.
Anyway,
so,
all right, question.
So AC on YouTube asked if we could post the city and county email addresses for the supervisors and the city council members, and we've already done that on YouTube. So again, if you may be watching on AOAUSA.com, our regular website. But if you go into YouTube, there's that more part. And if you click on that, it expands, and there's links in there and other things that we can put in. So if you go there, you'll be able to see it. Oh, in the YouTube chat. And yeah, maybe we can get that in the more section too. So it's in the YouTube chat for now. Okay. So, and then YouTube, Quinsful is the handle for this person. Is the county going to lift the moratorium on February 28th? And doesn't look, who knows, right?
No. And it's worth noting that the way the county moratorium legislation is written, it'll last for 60 days after the state of emergency is lifted. Now, they can change that. They can issue an amendment. They can just say, we're amending that to end it right now. But no, I mean, the state emergency, the statewide state of emergency will lift February 28th, which again, as we just talked about earlier, should have some, impact on the local councils and supervisors, but no guarantee.
Here's a good question. Is the eviction moratorium in Oakland and Berkeley applicable to tenants who move in now?
Yeah.
Yeah. If once it's over, then any 60-day protections would not be applicable to those people, but we're not there yet. Right?
Reading the ordinance, it just says, you shall not, you may not, and it doesn't distinguish. The state legislation did distinguish between tenancies that began after October 1st, 2022. Made a big difference. You didn't have to go through the hoops when you were filing an unlawful detainer that was otherwise permitted in your local jurisdiction, that you had to go through if the tenancy began before October 1st. But the local moratoriums don't make that distinction.
Oh, okay. Yeah, so that's interesting. Okay, so from the website, Don asked, would I proceed with a 3-day notice for a non-rent control house where the tenant is withholding the rent, asking for reimbursement of handbags that have mold on them? She claims it is from the house. Oh, what happened? I just lost that. But a restoration pro found no mold on any and only surface mildew around the single pane window in the room.
Yeah, obviously I can't provide, any specific legal advice like, yeah, you should go forward or anything like that. But, if there's no evidence that there's mold, that is the responsibility of the property owner. And if there's no evidence of actual mold, then that kind of answers that question. Then maybe that's your answer.
Right. And then they have to consider too, if they move forward with it, it may be contested and there may be, it may be difficult, right?
Yeah, I mean, and I have
not impossible, but
has been in touch with me in the last few days because she may be watching. Has a tenant that has in the property, she needs to do some electrical work to the outside service, PG&E panel, or the panel that's served by PG&E power, and it needs to be, either a new service but which wouldn't require going into the tenant's unit. But because the county inspector requires that anytime you do anything that requires a permit, apparently change of service does, that they then have to confirm that the hot water heater is strapped, which is inside the unit, So they need the tenant's cooperation. And the tenant says, well, you can't come in while I'm at work, but I'm at work all the time. And so therefore, they're, stymie. I'm just like, so she's like consulting with the lawyer. I'm like, I get how frustrating that must be. When the tenant just, all right, so what is the tenant's concern? Are they afraid that you're going to steal their stuff? You're going to come in with a county city inspector, PG&E, and you can videotape. So if that's, maybe they are worried about privacy. Maybe they have artwork that they don't, want to have strangers see. It's okay. So let's find out what is your problem, and let's try to address it. Because if you're not going to cooperate, then we have to go, like the Tina Turner song, we can do this the easy way, or we can do it the rough way. And so the rough way is a 3-day notice, compelling, attendance, or, and that probably would be an exception to the public health and safety moratorium. But again, that's just stupid money to spend when, you just try to work with the tenant to get their cooperation, unless they're just beyond salvation and just absolutely won't work with you.
Mm-hmm. Great. Hey, Rich, thank you so much. That's all the questions that we have for now. And time-wise, I think it's a good, we're good as well.
Yeah. I was out Monday because I think I mentioned before we got started, I had this weird little thing where I was sanding a door without protective goggles, and I got a piece of sand or something or dirt. Man, I was like Monday and Tuesday just like crying and barely able to do anything. So I am happy to turn back to some of my existing obligations. So. Oh, hey, I do have a question for you. When are you? We have an in-person coming up here. When is that? I look at my calendar tomorrow, and that's about as far ahead as I can.
You're right, I know.
Sometimes it's in a couple of weeks. Allison just called me to see if I needed a PowerPoint projector, and I always do. So I think
maybe the 20. I'm thinking it's the 22nd and the 23rd. One in Oakland,
right.
One in Santa Clara.
I'll be ready.
That's it. Yeah. So I know you're getting ready for
a different time though.
All right. Hey, well, thank you so much, and thank you everybody for watching. And we'll be able to see you in person, which is great. And then we'll keep doing this.
Okay. See you soon.
Okay. Thanks, Rich. Take care.
Bye-bye.
See you, everybody.